relief that is being promoted by the society. First, the welfare code. 2 articles are important. They govern youth programs. They do not mention municipal youth programs of any kind. So we start out with that basic fact. Next slide, please.
Sorry.
They do have a definition for children's institutions, very broadly defined, which I think they may rely upon to bring within the ambit of their regulatory authority any kind of youth recreation program. I frankly think that doesn't bear up under close scrutiny, as is apparent from the various other definitions in the code. If you could go to the next slide. Child daycare, that's a key definition in the statute. Child daycare center is defined in Title 10, but that definition, as you can see in the welfare code, is limited to for-profit enterprises, and therefore suggesting that the statutory authority to regulate such daycare centers would be limited to the for-profit, privately run facilities. Next slide, please. Now, the facility definition in the code is important because it does reference child daycare centers as we previously defined them. And as you know, the certification is issued to a facility. And that certification process is something that you've all struggled with in the last year and a half or 2 years. That definition is rather broad and does include child daycare centers, and it includes those that are operated by state or federal governments and supervised and licensed by the department. No reference to municipal programs, however. And the next slide. Now we enter the thicket of the DHS Child Daycare Center regulatory regime. Now, this is the principal basis for the department's assertion of authority over preschool municipal recreation programs. Now, the care provided, it includes care provided in a public or private or public profit or nonprofit facilities. So it would appear that that regulation brings within the regulatory regime municipal youth recreation programs. Next slide, please. Now, they have broad definitions of what is a legal entity, which would include municipalities and all manner of entities who would be subject to the certification requirement. There's no specific reference to a local government entity, however, and that does reinforce, I believe, my opinion that these regulations are principally directed at the private sector. Next slide, please. Now, child daycare center, this is where the rubber hits the road from a regulatory standpoint. Clearly, that would include any premises in which you would run a youth program of any kind, be it municipal or otherwise. Now, the regulations specifically apply to, or the certification would apply to preschool children, a child from 3 years of age up through the date they're eligible to enter kindergarten. So we're really focused on the preschool program certification issue. And that is the reason there, that last paragraph on that slide. And next slide, please. There is no question that the regulations omit any specific reference to preschool part day programs. And the definitional section of the regulations do not refer to municipalities, authorities, or any public entities. So at first glance, the applicability of these regulations to municipal or public preschool recreation programs is somewhat sketchy. Next slide. Then we get into the operational requirements that they insist upon as part of the certification process, the operational requirements and the facility specifications. That is where preschool recreation programs do not really fit the regulatory regime. Unless you have a rec center, an extensive facility like that, the programs that you typically run, especially the outdoor programs, would never be able to meet the facility requirements. They have, again, the facility requirements are geared toward your classic child daycare center operation. And then you have staffing requirements and training requirements. So given all that, after we have met with the Department of Human Services at length and engaged them in hopefully a constructive dialogue, we have been rebuffed. And the agency has taken the position that their requirements are their requirements and they must be satisfied. Next slide, please. Now, as you well know, all too painfully aware that the certification compliance application process is very burdensome and waivers are seldom granted. Consequently, many of you have struggled to obtain certifications, and many times you're dealing with a very a faceless and obdurate government bureaucracy that's not terribly, shall we say, responsive to your concerns. And it would appear too that the agency itself admittedly lacks the resources to enforce these regulations and properly police and administer the certification requirements. So they typically pick out low-hanging fruit like Philadelphia for some of their more drastic enforcement actions. Now, these certificate of compliance requirements up here on the slide cover all aspects of a program's operations. The staff accreditation, physical site requirements, equipment, and the actual programmatic structure of the program itself. Next slide. Tim Hurd and the Society has come to the rightful conclusion that legislative relief is necessary. And as you know, there was a 2016 survey, and the findings of those surveys, findings of that survey were used in preparing remedial legislation. The draft legislation essentially incorporates, and I'll summarize this, legislation that was proposed in the House would have allowed for the operation of a public preschool recreation program that adopted by ordinance the society's protocols. The protocols were carefully crafted by Tim Hurd and his colleagues so that they satisfy the letter, if not the spirit, if not the letter, of the certification regulatory requirements, keeping in mind that you've got a very wide range of municipal recreation programs throughout the state. Now, Tim, if you could elaborate on that a little bit, the protocols and where we are with the legislation.
The protocols address the parts of the code that we felt were applicable to municipal preschool recreation programs. And we don't have it here as part of the slides, but we do have that protocol on the BRPS website under resources under preschool, which is where you can find it readily. And of those things, it addresses the things that we have the control on. So it's about enrollment, numbers of enrollment, its length and duration of the program, it's the training and supervision of the staff, and things like that. What it does not include are facilities, because if you are doing a preschool program outside in the park, we can't address things like places to nap for preschoolers, or tiny toilets that are required in facilities. So we had thought, if through our first discussion with DHS, that we had understood that they had some discretion in how they would enforce this. And so that was why we proposed the protocol in the first place, because it did address what were the applicable parts of the code to a recreation program. Well, they turned us down flat, and as Jeff said, that's that. So the legislation that has been proposed in the House includes that protocol, that if municipality signs on to that protocol by ordinance or resolution, that they're adopting this as the framework in which they operate, that would then satisfy and essentially exempt the municipality from being forced to comply as a child daycare center. We testified end of October before the House Children and Youth Committee with, I think, persuasive arguments in favor of our line of thinking, including letters of oral and written testimony from those across the state who are dealing with this issue. And we, in fact, seem to have support from the majority of the representatives on the committee, with the exception of the chair of the committee, who has to date refused to release it from the committee out to the House for any sort of vote. So it seems to be stuck there at this point. So our next avenue of action would be to introduce a Senate companion bill to this House bill that would, of course, report to a different committee on the Senate side. And that is in the works. However, because of the current pandemic, where all the attention these days in the General Assembly is about COVID relief and so on, that probably won't be introduced until this fall, is what we're thinking. But we may have more of a chance from that angle to move forward with getting to our intended ends on this, is to be out from the regulatory enforcement to the child daycare center code.
And I must say, having sat in the cheap seats during that hearing, that Tim and his colleagues did an outstanding job, and your members really gave what I thought was very persuasive testimony about the programs that you all have sponsored over the years. And many of the committee members were quite receptive. But for some reason, the chair of the committee, who has apparently absolute authority over whether the committee, to decide whether the committee even votes on a bill, has refused to even release that bill for a vote before her own committee. And that's been very frustrating. And that's why Tim says it's best to pivot and move to the Senate, where I think we'd get a better reception, frankly.
I'd also add that we do, I'm pretty sure we did post the full written testimony from that hearing also on the website under those same pages that if you're interested, you can read all about it.
Well, we can next move on to the next slide, introduce a new topic, and that is Act 87 of 2019. As if things aren't more legally troublesome with the certification issue we've just discussed, the legislature has decided to throw in an additional, shall we say, challenge for all municipalities, and I'll explain how this new legislation would impact municipal recreation programs. In 2019, as of November 26th, I believe, 2019, they enacted a immunity exception for sexual abuse, the sexual abuse immunity exception under the Pennsylvania Tort Claims Act. It's a new immunity exception. As you all may know, municipalities and other public entities are immune from liability, subject to tort liability, subject to certain exceptions. So they added the sexual abuse immunity exception, which essentially is uncapped. All the other exceptions have a damages cap, $500,000. This has no damage cap, so it creates potentially unlimited damages liability exposure. Secondly, the immunity exception only requires ordinary negligence for there to be liability. And what it says, frankly, is that it describes sexual abuse as conduct that constitutes an offense enumerated under a particular statute if the injuries to the plaintiff were caused by actions or omissions of the local agency which constitute negligence. Plainly, this is written by plaintiff's counsel for the most part, and it sets an ordinary negligence standard for liability under this immunity exception. So it is something that is going to be quite challenging for municipalities to address. The sexual offenses that fall within the definition of this sexual abuse immunity exception are enumerated in statute, and they range from human trafficking all the way through aggravated indecent assault, rape, and incest. Every conceivable sexual crime or offense would be covered within the ambit of this immunity exception. Also, and again in reaction to, I believe, the child abuse scandals that you've seen over the years, both in the church and I think to some extent at Penn State, they extended the statute of limitations for sexual abuse claims retroactively, such that if you're the victim of childhood sexual abuse, you have until age 55 in which to file an action or a claim. This would be, by the way, the sexual abuse immunity exception is limited to sexual abuse of minors under the age of 18. And the extended statute of limitations would apply only to actions for civil actions for sexual abuse for which the limitations period had not yet run as of November 26th of 2019, and where and it wouldn't apply to claims that were resolved, settled, or otherwise resolved dispositively. But for claims that would otherwise not be barred under the pre-existing limitations period, the liability limitations period would be retroactively extended, so that the claimant would have, or the plaintiff would have, until they reach the age of 55 to file the claim. Now, what impact does this have on municipal recreation programs? Let me explain very bluntly that there are two scenarios, if you will, that a municipality could be liable under this sexual abuse immunity exception arising out of the recreation programs. and that is the negligent vetting of employees and volunteers under the CPSL, such that you would actually have an employee or volunteer who ultimately is a sexual perpetrator. You would be then liable for negligent hiring and vetting of that individual. You could also have lax or negligent supervision and training of the individuals, such that if you were to not have appropriate security or oversight of the participants in the program, and they would then somehow be at risk, and God forbid, a child is abused by a stranger, if you will, while participating in the program because of lax security or whatever, that too could raise a liability scenario for which a municipality could be exposed to unlimited damages under the sexual abuse immunity exception. Now, the good news is, according to Tim, that there have been very few, if any, claims for sexual abuse arising out of the public recreation youth programs. And we take that to heart because, frankly, that really gets to the heart of the risk itself. But let's put it this way, the stakes have been raised considerably with the enactment of this new law, such that our strong recommendation is that the CPSL certification requirements be strictly adhered to. Ever more emphasis placed on them, the vetting, the training, the oversight of employees and volunteers, the precautions that are taken so that you don't have many opportunities where a child is alone with an adult or minor volunteer, if you will, out of sight of others, so that you don't have an atmosphere or an environment that would lend itself to this sort of misconduct or make it even possible. Obviously, you all are well equipped to deal with the issue. You've managed your programs very well over the years. No reason to think that's going to change, certainly. But again, I wanted to advise you of the new law such that this is now presents a rather significant liability exposure for claims of this nature. We can turn to the next slide, and I'll talk about a related issue. And that is the proposed constitutional amendment. A number of states have done this, where they have adopted, there's a resolution that was adopted by the General Assembly, which basically was passed authorizing the submission of a constitutional amendment. That constitutional amendment would create a 2-year window for the filing of what I would call stale or long barred sexual abuse claims going back decades. And that 2-year window would be, I think, in some cases subject to in and of themselves, a federal constitutional challenge. Although this is an amendment to the Pennsylvania Constitution, the legality of such a constitutional provision in Pennsylvania would be subject to the United States Constitution. And that raises a whole host of issues. The constitutional amendment itself will not be ratified until May of 2021 at the earliest, given the schedule set out in the resolution. Obviously, this will, once it passes, will potentially expose municipalities through their recreation programs and otherwise to greater liability from individuals who claim to have been abused while they participated in the recreation programs decades ago. And of course, during this 2-year period, sort of those claims could be filed. Now, there are significant legal issues surrounding that. I'm not going to get into all the gory details, but the bottom line is that you can extend retroactively by constitutional amendment a limitations period, subject to the requirement that you're not, in effect, making otherwise making it a statutory offense which did not exist, creating a statutory offense retroactively, which didn't exist when the individual tort or abuse was committed. And there are also issues as to the ability of a defendant municipality to properly defend itself with the passage of time, the loss of evidence, that sort of thing. That, in my judgment, is probably the soundest legal challenge to any such claims arising under this constitutional amendment, because you really will not be able to defend against these actions decades after they've occurred. Witnesses have died, documents are lost. You'll have the uncorroborated. Many cases you'll have just a testimony of the victim, and the defendant will be at a distinct disadvantage. But courts do take that into account in deciding whether a particular defendant's due process rights were violated as a consequence of the filing of a claim under a constitutional amendment of this type. This is uncharted territory, to be sure. These 2-year windows for the filing of long barred claims, and that it would be childhood sexual abuse claims, just been enacted in the last year or so throughout the country. So we'll see how that unfolds. But again, the best way to deal with that is to just hope that your programs, having been run in the past, will run properly, and you just have to deal with these claims as they arise, and legal challenges will be made. But prospectively, obviously, strict adherence to the CPSL requirements is the best way to avoid liability under the sexual abuse immunity exception. Let's turn to the last issue, and that would be
Jeff, this is
sure.
Tim. Just as a matter of operational adjustments in light of this, Jeff mentioned, strict compliance with the Child Protective Services law will be helpful, but you want to keep those records indefinitely at this point, rather than whatever protocol you've been following for 5 years or 7 years or whatever, and digitize them if you have to. But 30 or 40 years from now, the people who follow you in that place may be grateful for it. But as well, you might want to review or update any leases or contracts that you have with schools and independent contractors for municipally sponsored or private run programs. Somebody that comes in and runs a dance program or a yoga or karate or something that isn't on the staff, but you contract privately for them, and review the agreements that you have with them to mitigate any liability exposure and ensure adequate insurance coverage. And then additionally, while you're reviewing your overall employment policies, including those on your personnel management, your workplace operations, employee conduct, supervision, job descriptions, for best practices with respect to future liability claims. I see we just placed up on the screen a document we produced in March, and the March guidance and resources for new laws affecting recreation operations, workforce, and compliance, that speaks to the Pennsylvania Child Care Code that we started with, and this Act 87, as well as what we're moving on to now here, Act 47, provisional hiring issue.
Just put a link in there for all our participants.
And we'll have time at the end for questions that may be submitted via the chat box if you got them.
Yeah, Tim,
Okay.
can I echo that? Right now, the chat box, we have some links in there, but if you do have questions, we've just tackled two very big topics and working on our third. If you have any related questions, please enter them in the chat box or the Q&A box. We'll see them and we'll definitely tackle them at the end of this presentation.
So if we can go on to the next and the last slide. Well, next to last slide. Provisional hiring ban. As you know, Act 47 of 2019, the legislative hits just keep on coming. Effectively eliminated provisional hiring by programs that are not certified as child daycare centers as it relates to the preschool programs. So consequently, the good news here is that House Bill number 360, which would provide relief from this ban through the end of the year, was passed by the Senate and is now sitting on Governor Wolf's desk. And Tim, if you could explain a little bit more about that legislation.
Yes, the Act 47 was about to be a tremendous silent, so far, disaster here, as people would be hiring, especially a lot of seasonal staff for the summer, and who would not be able to start their jobs while they await their clearances. Now, the Pennsylvania criminal history check and the child abuse clearances come rather quickly these days, but the FBI fingerprints can take weeks, and Act 47 banned that except for certified or licensed child daycare centers, which again excludes all municipal recreation programs, or virtually all of them, which meant that your summer staff could no longer benefit from a 90-day waiver or a provisional hire while they awaited their clearances. Nor could they, under Act 47, even start their job of other responsibilities away from direct contact with children, or even under direct supervision of somebody who has their clearances. It just shut that all down. And you throw in tens of thousands of people into the clearances system awaiting, it always creates a backup, and this would be even more so this year because it includes those that first certified under this 5 years ago and now have to recertify. So we've been hollering about this since we discovered it last fall, yet no one could hear us at the legislative level practically. But as Jeff said, this House Bill 360 that was passed just last week would give us a temporary solution for this year. It allows that the people who require recertification have until the end of this year to obtain the federal criminal history record that requires fingerprints, as long as the other background checks have been completed. And then for those who are applying for the first time for their clearances, it would also give them until the end of the year for the same FBI fingerprints clearances, provided they have met a couple other requirements. They must have lived in Pennsylvania for the previous 10 years or submit an equivalent of state police background checks in other states for the time that they lived out of Pennsylvania. They must submit their Pennsylvania State Police and statewide child abuse database background checks. The employer, administrator, supervisor, or person responsible for employment decisions shall document the reasons that federal criminal history and fingerprinting requirements cannot be completed. The applicant also affirms in writing that they have not been convicted of any one of an enumerated list of crimes. And finally, that the federal criminal history and fingerprinting checks must be submitted by December 31st, 2020, or within 60 days of the termination of the governor's COVID emergency declaration. So given those conditions, however, it gives some relief to the immediate problem of being able to staff up in a quick response once your county or region has emerged from red to yellow to green to resume non-quarantined behaviors and perhaps get some outdoor recreation programs going yet for the summer without the additional burden of what Act 47 would have imposed. And so that's for the immediate, which we're glad. But after the termination of emergency declarations or after the end of this year, as it stands now, we revert to the provisions of Act 47, and which means no provisional hiring unless you have, unless you are a licensed child care center. And even then, you must apply to DHS for a waiver of 45 days. So we have a bill that is about to be introduced, possibly even yet this week, by Representative Miller of Lancaster County, which would be a provisional hiring parity bill, which would provide the same allowances to non-child care centers to apply for a waiver of 45 days that would assist you to be able to hire somebody provisionally and get them started in their duties while they await those FBI clearances, which, by the way, many of them are even shut down during this current time if you had even wanted to get them right away. There's a delay because of that as well. So stay tuned for news on that bill. We don't have a bill number yet on it, but the provisional hiring parity bill that will likely be introduced very soon in the Pennsylvania House, and hopefully passed with support perhaps from you who are listening and your agencies, letters to your representatives in support of passage of that bill. Stay tuned on it. We'll get more out on that when it's available. We have something substantial to share.
Well, Dan, I guess we can take questions now.
Okay, I am going to encourage folks to enter questions into the chat box or the Q&A where I can read them out.
Meanwhile, I might say,
and I have
might want to
unmuted.
start your recruitment and hiring and training process earlier than you would. Well, it's probably no longer any earlier than you would, but to get that in place anyway, for the eventuality that you may be able to staff up and program up and still provide things for them yet this summer.
All right, Suda has raised their hand, and I'm going to unmute them. I can't seem to. Oh, there you go. Unmute. Oh. All participants are unmuted right now, so please go ahead and say your questions. Well, to start things off, I do have a question for you. Jeff, in the first part about daycare centers, you had mentioned in the legislation it was written for private, or the word private was used to identify the centers. Do you see that as like a sort of a wedge that can be used going forward on trying to make this this whole situation a little more tenable for people in the recreation field?
I think I think that may not be much of a wedge unless you file a declaratory judgment action. I think given the sentiment of the agency and its determination to apply its regs, which literally I think are being misapplied, but could be construed as applicable to a preschool recreation program. If nothing else, because of the overwhelming interest in protecting children, I think the best way to do it is use it as a wedge, not in litigation, but in sitting down with the agency and the legislators and making it very clear that the remedial legislation will adopt protocols that largely mirror, certainly in effectiveness, or the functional equivalent of the requirements for a child daycare center, absent all the facility requirements that obviously you can't meet. But with the idea that the protocols as proposed will protect the children. And that is the sole purpose of the certification regime, if you will. So I think that's, to that extent, it's an argument that I obviously can be made better in the Senate than the House, because the House committee, as Tim mentioned, is sort of dead to us as far as the chairman's refusal to move the legislation. I think we can have very constructive dialogue with the Senate staffers, arguing that from a legal or statutory standpoint, the agency's engaged in an overreach. And that these programs were never intended, these recreation programs were never intended to comply with child daycare center requirements, and never have for decades that they've been in existence. I think that that argument does carry weight from a public policy legal standpoint, but I wouldn't litigate the issue, frankly. I think it provides us with a very strong talking point, if you will, with the legislative staff and the senators when and if the remedial legislation is revived and presented in the Senate.
Okay, thank you. Tim, I had a follow-up for you also, as I was listening to you describe the clearance requirements for new employees and employees who need to get renewal on their clearances. I was wondering, did you find out anything as it would pertain to a volunteer or volunteers?
This, this act, or the House Bill 360 that was passed, does not apply to volunteers. So volunteers would still fall under the requirements of Act 47, meaning that they couldn't start any of the duties until those clearances are in hand.
Hmm, okay.
So if you have a friends group, for example, that might have in their course of whatever they do a program or cleaning up a park or something or a playground and have potential for direct contact with children, that's where that would apply. If you have volunteers that do not, as part of their job description or their duties, have contact with children, then this does not apply to them.
Okay. Oh, I have a question here in the question answer box. My preschool camp counselor is a preschool teacher at one church, and we pay a small fee to use a church preschool classroom in a different church. Is there anything we need to be concerned with as far as using the facility?
In the child care code, the licenses are granted to specific facilities. And so if you have a program that happens in different places, each of those places would have to
Mhm.
have that certification, as I'm understanding.
Yes.
So if say in another example, you have after school programs and it happens in 4 different elementary schools, each one of them would have to get their separate certification for that. It wouldn't matter that you may have the same staff or same personnel running the program, but if it's in the different location, that's how the code is going to catch that. Anything to add there, Jeff?
No, I think you've got it.
Okay. All right. I don't see any more questions coming up.
Here's one came, I see. It says, how would it apply to field trips?
Ah, there you go.
If you're talking field trip the way I did as a naturalist and leading people out into the woods, that's one thing. But if you're talking about a field trip like a bus trip to a different destination, like going to the zoo, that complicates things considerably. We have not included transportation in our PRPS protocol for preschool programs because that requires a whole nother slate of additional requirements and precautions on that. And Jeff, if you could add to that.
I really can't. I think you made the point. The protocols don't deal with transportation, but I think in the testimony you gave in October of 2019, wasn't that the focus of some of the questions, at least from the chairman?
They did ask us about that because that was one of the countering claims from DHS that we did not address any transportation. And that was on purpose because we said for preschoolers,
Right.
That
Not an issue.
it's asking for problems that you don't need. So in our protocol, we say don't do that. Don't be taking preschoolers away from the site that they come to you in.
Right.
Hold your programs right there.
I can speak from experience. I did oversee a preschool program, and you're looking at 3 to 5 year olds, and many of them,
Right.
well, they require car seats or special busing to do field trips. So that that's one big obstacle. But as far as the liability on the place where you visit, I don't think the same regulations hold for a field trip destination. I mean, you still have to have the supervision and the
Right.
qualified teachers and things like that, but I don't think the same facility regulations hold.
No, the the certifications are facility based. So
Mhm.
that transportation would be outside the scope of that.
Mhm. We do have another question or a comment. It may be worth noting that on the keepkidssafepa.gov website, it states that volunteers need to attain the FBI fingerprint clearance if they lived in PA for the last 10 years and are willing to swear sign in writing that they are not disqualified. Oh, they need not obtain the FBI fingerprint.
Right.
Yes. Yes. Thank you, Eric. Appreciate that.
And I want to do this. Okay, well, it looks like we're done with the questions. So first and foremost, I want to thank Tim and Jeff for your expertise in presenting this webinar. I think we all learned a lot. It was an interesting presentation and some good updates, at least for the time being. Individuals who are desiring continuing education credit for this webinar must complete the quiz to obtain their credits. A letter of completion will be emailed to you from the Pennsylvania Rec and Park Society following the webinar. So please go to this website. It's a SurveyMonkey /r/ ACT ACT4787. And there'll be a quiz there that you can go. Once you complete the quiz, you will receive a letter for certification. So I'm going to leave this screen up for a little while so you can have time to copy it and paste it in. But thank you everyone for attending this webinar. I hope you learned something, and we look forward to having you attend more PRPS events in the future.
Our pleasure. Thank you.
Thank you. And I appreciate everybody spending their time with us, and spread the word to your colleagues and to those you report to in the municipalities about the ramifications of these new laws and what that means to them as well as you. Thanks so much.
Thank you.